So hello again. Since I've come such a long way, I decided to speak some more. No, this is very last minute, and I'm afraid it wasn't what was in the initial agenda for today, but it's kind of always a hot topic, so it might also leave room for some discussion or questions or a debate. So hopefully just during a few minutes we'll go over the general framework of this topic. Okay, so as we've seen basically during all the presentations of the morning prior to the coffee break, we see that sport is an industry. It's not just sport, it's not just an instrument of social cohesion and cultural and bringing together the peoples of the world, which it also does. But it is certainly an industry and a very valuable industry. And EU institutions, particularly the Commission and certainly the Parliament, with initiatives like the Europe 2020 program, the White Paper on Sport, have made it abundantly clear that the economic dimension of sport should certainly be fostered and promoted to be able to allow this industry to fund its initiatives, which have a spillover effect in many other aspects, in society, in infrastructures, in grassroots programs, etc. So the impact of sport and what it does has been abundantly established. How do image rights come into play? These image rights, as opposed to other rights, like we've seen a great deal of harmonization, for instance, at trademark level, with different initiatives, with a directive, with bodies such as EU IPO, working very hard to harmonize practices, to harmonize initiatives, programs, etc., even computer tools for searches, for establishing similarity, for fighting piracy. However, it is somewhat puzzling that image rights that have and carry such an important weight, such an important economic weight in the sports field, are subject to little or no harmonization throughout the European territory, and certainly not worldwide. And this is particularly puzzling because of the international dimension of sport, because of the international dimension of the outreach of sport, because of the importance of broadcasting, and not just traditional broadcasting, radio and television, but also, as we've seen in earlier presentations today, also in digital platforms, social media, etc. So it's kind of bewildering that such a relevant economic aspect of these rights has not been subject to more harmonization, and it doesn't seem to be, at least in the pipeline. So how is this issue approached in these different jurisdictions? In the US, it is the right of publicity. It's what is called image rights, or what we tend to call image rights. It's considered certainly an economic right. In continental Europe, as opposed to the UK, which is, as we've seen in recent times, has its own way of doing things. It doesn't recognize a general privacy right or a right of personal portrayal. So we see that all these different systems coexist. However, the games of Real Madrid and the likeness of players are used in all these territories. So how do you, when you put all those elements, all those ingredients in the blender, what comes out? The issue is that you have very complex agreements, and negotiating those agreements is quite the headache, because you need to take into account all the contractual and regulatory differences. You also have to take into account that there are no borders, especially with the internet and social media, and that you need to be extremely exhaustive, because everything that you don't put in the paper is simply not on the paper, especially when you're dealing with non-continental or non-civil law-based countries or jurisdictions. So the tendency is to draft agreements that are this thick and that try to be ironclad, to try to anticipate any potential situation that can arise in the framework of that relationship. And as we know, or as we lawyers know, it's just as bad to have a very vague and very non-specific agreement than to have an extremely specific agreement. Because if you have very exhaustive language, obviously what hasn't been specifically put in is not contemplated by the scope of the agreement. So it's tremendously difficult to negotiate these contracts. Now that I think of it, and actually I was in the coffee break, I was thinking I should have put, instead of a picture of Sergio Ramos, the Spanish football player, I should have maybe used Kaspars Gorkš or another Latvian athlete. But I guess my heart is with Real Madrid. So there you go, Sergio Ramos. Who owns these image rights? Image rights are owned, obviously, by the natural person whose name or voice or likeness or other features are used to identify that natural person. Legal persons have no image as such, although they can be derivative holders of image rights. Image rights constitute a hugely important part of what players or what athletes obtain, because you have to take into account that not only what they obtain as wages, so to speak, for their work as athletes, as footballers, as tennis players, is at hand. Sometimes they obtain much, much more from the exploitation of their image rights through sponsorship contracts, through licensing agreements, any which way in which their likeness, their appearance, their sound, anything that their voice that identifies that natural person is linked to a certain brand, for instance. They're very controversial issues, and this was certainly a very controversial issue back in the day, and it was the traditional playing cards relating to football players. Because, of course, to what extent do you have to negotiate individually? Do you imagine having to negotiate individually with every single team and every single player to be able to produce a collection of cards, playing cards. That would be nothing short of impossible, almost. So what happens in Spain, at least, the current situation, is that La Liga, the professional or the Premier League, so to speak, represents the clubs and is able to negotiate collectively on behalf of all the football clubs, whereas the Professional Footballers Association negotiates collectively on behalf of the footballers. And together, they are able to license to the companies producing those playing cards, the albums, I'm thinking, how do you call those little stacking buttons that have, I can't remember their name, but basically they're also little playing tokens with the figurines or the names and the likeness of the players. So they collectively negotiate on behalf of those two parties, and at the end of the day, they split the revenue. They're not exactly 50-50, but almost. It's something like 60-40 or 65. And they split the revenue that they obtain from that commercial use of the likeness of and the insignia, etc., of the clubs and of the players. However, to what extent and what the Anglo-Saxon world called fair use, would there be fair use to use the names of the clubs and the likeness and the features and the identifying features of the players? Well, this was also an extremely controversial issue that was raised back in the day, with the galactic Real Madrid being part of this suit that was brought by a number of major football clubs, major European football clubs, and many players, including David Beckham and Zinedine Zidane. And what they were arguing was that they had not given express authorization to a number of betting houses, including bwin, William Hill, etc., to use their names, their likeness, or the imagery relating to the clubs in connection with those betting services, okay, which is also a very controversial issue. Gaming in general, not only regulatory, but also from a perspective of people who have serious problems with betting and gaming, etc. So it was they also argued that apart from the dimension of whether they had or had not given authorization, they were not very comfortable with being associated with certain services. Okay? This was, I have to say, over 10 years ago. So the betting situation was not as we know it today. There was even a preliminary ruling by the Court of Justice, and what the Liège Court of Commerce determined was that it was covered by the doctrine of factual reporting because it was simply not possible to offer those services without using those names or without using those particular signs. Okay, so looking back, it kind of reminds us when you're looking for flights on the internet and you see the different logos of the air companies that you can fly with, and you see the names and you see the logos of those companies, like the Iberia, the British Airways, whatever. Okay, so it would be kind of a similar situation in which it was determined that this was what the British would call and what the Americans would call fair use. However, in the United States, where freedom of speech is almost a religion, a very similar case to the playing cards that we saw earlier reached very different conclusions. So basically, they considered that this was part of public discourse that was healthy, that was good for society, and that should be considered covered by free speech. So even though you have absolutely recognizable faces and depictions of players, and even of, in this case, baseball teams, it was considered fair use for those reasons. This is also a very interesting case relating to tattoos, which in the last few years certainly have become increasingly popular. And it is the question of whether athletes literally own their own skin. This is also linked to a highly hot topic right now. It certainly was today. It's the world of video games. So what happens when a video game portrays a particular athlete, tattoos included? Are they allowed to do that? Because obviously you want the depiction of the athlete to be as close to reality as possible. And it is true that those tattoos form part of the identity of that athlete. There are perhaps less imaginative tattoos, but certainly there are very characteristic tattoos. Like think of Mike Tyson's very specific Maori tattoo on his face, which I will go back to later. So what happened here? That the ink or the tattoo company sued, arguing that it constituted a copyright infringement. They claimed that showing those tattoos was unauthorized, and obviously that the video game should stop showing those tattoos. In this case, it was perhaps the most famous of the athletes that were portrayed in the video game was LeBron James. So incredibly enough, the case is ongoing because the request for summary judgment was dismissed. The judge was not convinced that this was an easy, straightforward case. So it was agreed that the case would go on. My gut feeling is that it will be settled, but it was certainly extremely controversial to the extent, how can you possibly portray an athlete without all its characteristic features, including the tattoos? Oh, hold on, let me just go back and Paldies. The issue of the tattoo is also extremely interesting from another point of view. If you look at the other face of the same token, because you've probably heard of a movie called The Hangover, where obviously a group of friends go to Vegas, one of them is getting married, and they wake up the next morning with a total blackout. They don't know what's happened the night before, but they find themselves in very strange situations. And one of those friends wakes up the morning after with Mike Tyson's Maori tattoo on his face. And sure enough, the tattoo artist sued and tried to stop the release of the film based on copyright infringement. So although the case was ultimately settled, what is interesting about that case is if you look at it from the other point of view, not from the point of view of the rights you can assert, but what you can stop other people from doing when you assert copyright rights, is that you would it would basically entail that if someone wanted to remove a tattoo or alter it because, you don't love Jane anymore, or you're divorced Jane. Think of Angelina Jolie. She probably had Brad somewhere in there. What happens if you want to remove it? Because if you stick to the laws of copyright, you couldn't alter this work, correct? So you can't remove it, you can't alter it, you can't make a flower out of your ex-husband's name. So one of the arguments that the judge gave, which I found to be very interesting, is that it would be tantamount to branding cattle. When in the West you would brand a cow to show the world that cow was yours, and that would be unaltered. They would not be able to change that hide. So it would be kind of admitting the same is possible for human beings. So it's kind of a very tricky, slippery slope situation right there. We'll see how that evolves. And also, there is the question of tattoos where those tattoos consist of trademarks of third parties that they are asked to cover because it is not the official sponsor of the particular team. So what happens if you tattoo a swoosh mark, or if you tattoo the very famous Michael Jordan jumping in the air with legs spread out mark, or the Supreme trademark that now a player has recently tattooed on his whole leg. So very interesting issues right there. And sorry for this very last minute I put together last night at the hotel. So I hope this gives you also some food for thought and some takeaways from the session today. Do you have any questions? Paldies. Thank you. Yes.
Just one comment. Actually, there is also a decision of one Belgian court that says that I would like to.
Yes.
Yes, this issue regarding tattoos is really very important, now interesting, but there's also one interesting decision of Belgium court that says that if one person would like to remove a tattoo on his body, that these private rights are higher than the rights of tattoo artists. So the person would be able or would be entitled to remove this tattoo. So, but these are really now very tricky issues.
Of course.
Yes.
Very much so, because obviously you always find yourself in a position where you need to balance the rights. It's like, okay, IP rights versus freedom of speech. Is it copyrights versus individual rights of a human being to be able to own his own skin and his own body? There's another question, I think. Yes.
No? Okay. Well, first of all, many thanks for both presentations. They have been really complete and really concise. And it's related to the sport industry. Of course, it moves millions of dollars, but I would like to know how is it really affecting the taxation and the tax law?
Okay. First of all, I'm not a tax expert at all, so I hope you don't hold it against me. It's an extremely difficult issue. It's highly controversial, especially in the last few years. I'm sure you've heard of very big cases against big stars. In Spain, for instance, there's been a number of very high-profile cases involving stars like Messi and Ronaldo as well. And the question essentially lies with the structure, how you structure your taxes, because what is clear is that what the athlete obtains for his athletic work, so to speak, is subject to, the general rules, what any worker would perceive for his or her work. However, when you put a company into the equation, to manage those rights? Well, the tax regime is considerably more benevolent than for physical or natural persons. So that was a preferred structure for many years. The problem was that there was nothing really there. It was kind of like an empty shell. So what everybody was doing, or most everyone was doing, was creating a specific corporate structure that would be the owner of those image rights and would then license and conclude agreements with big brands for the exploitation of those rights. But the truth was there were no employees, no real corporate activity. There was nothing really there. So there were big tax avoidance issues, not just in Spain, certainly across the EU and certainly in the UK. So that still remains a highly controversial issue, and we'll see how that evolves. Certainly in Spain, I can tell you that the fiscal and tax authorities weren't buying. That was actually, real companies doing real company work. So what they were asking the players to do was to pay up what they should have paid, considering that they were natural. They were dealing with income of natural persons, physical persons. Good question, thank you.